Good evening, everyone. My name is Mark Gary. I'm privileged to serve as the Executive Vice Chancellor of the Jewish Theological Seminary, and I'd like to welcome all of you here today for the Bernard G. Segal Memorial Lecture in Law and Ethics. For some of you, this may be your first time at JTS, and so I want to extend a very special welcome to all of you and express my hope that we'll see you in many times in the future at future programs. At this time, I'd like everyone here to engage in an ancient Jewish ritual, and please silence your cell phones. I'm also delighted to welcome all of our live stream viewers. It's wonderful that we're able to share tonight's program with so many people throughout the United States who are viewing this via the live stream. We're particularly pleased and very excited that a number of synagogues have partnered with JTS by holding public screenings of tonight's program. And so I'd like to extend a very special welcome to these synagogues. Temple Judea of Laguna Woods, California, the Emmanuel Synagogue in West Hartford, Connecticut, Congregation Beth Judea in Long Grove, Illinois, Beth El Synagogue in Omaha, Nebraska, Malvern Jewish Center, Malvern, New York, Congregation Agudat Achim in Schenectady, New York, Beth David Synagogue, Greensboro, North Carolina, Tiferet Israel, Columbus, Ohio, and to all the other groups that are joining us, or the individuals who are joining us through live stream. It's our great pleasure and our honor to be joined by tonight's speaker, the former U.S. Solicitor General, Seth P. Waxman. His topic will be Supreme Court cases and Jewish values. As an institution that's deeply committed to halakha, to Jewish law, and to the role and relevance of the courts and the American legal system in the field of ethics, JTS is the ideal venue for tonight's presentation by Mr. Waxman. This annual memorial lecture was established by JTS in honor of the late Bernard G. Segal. A philanthropist and community leader, Mr. Segal was the first Jewish president of the American Bar Association and the first Jewish chancellor of the Philadelphia Bar Association. In addition to his longtime career with the law firm of Schneider, Harrison, Segal, and Lewis, Bernard Segal carried out special assignments for Presidents Eisenhower, Kennedy, Johnson, and Nixon, and worked tirelessly to extend the influence of the organized bar in matters of legal policy nationwide. Mr. Segal was recognized for his tireless efforts to expand and improve legal services for the poor, the powerless, and the dispossessed. And if I could add sort of a semi-personal reflection, as a member of the Board of Trustees of the Lawyers Committee for Civil Rights Under Law, we often tell the story of the time when President Kennedy, during the real heat of the civil rights movement in the early 60s, was watching television and seeing what was happening with African American demonstrators and other civil rights demonstrators in the South, how they were being jailed, how they were being mistreated. And he turned to his Attorney General, to his brother, Robert Kennedy, and said famously, "Where are all the lawyers?" And Robert Kennedy said, "I don't know, but we're going to find out." And the first call he made was to Bernard Segal. And from that, and the meeting that ensued that Mr. Segal called of other major partners of law firms, came out of the Lawyers Committee for Civil Rights Under Law, which is one of the major civil rights advocacy groups in the United States today. Mr. Segal also serves as alma mater, the University of Pennsylvania, the Jewish Publication Society, the Philadelphia Allied Jewish Appeal, and the Hebrew University, where the law library bears his name. In addition to this evening's annual lecture, his support for JTS which awarded him an honorary Doctor of Laws degree in 1977, has been recognized through the naming of the Bernard G. Segal Seminar Room in our Kripke Tower. At this time, I am particularly delighted to welcome Mr. Segal's grandchildren, Mr. Mark Cohen, Ms. Jennifer Cohen, and Ms. Meredith Segal. And I note that Ms. Cohen is joining us for the first time, so a very, very, very special welcome to her. I'm also very pleased to welcome Mr. Bruce Rosenfield, a former law partner of Bernard Segal, and to thank him for helping bring this program to fruition. It's wonderful, of course, to be with you again this evening. It's now my great pleasure to introduce our speaker for tonight. Seth Waxman was the Solicitor General of the United States from 1997 to 2001. He is generally considered, virtually throughout the legal profession, to be one of the premier Supreme Court advocates of this generation. Earlier this year, he delivered his 80th oral argument before the Supreme Court. A graduate summa cum laude of Harvard College and the Yale Law School, he is a partner at Wilmer, Cutler, Pickering, Hale, and Dorr, and a member of the faculty of the Georgetown University Law Center. His clients range from financial institutions to consumer, industrial and media companies, from death row inmates to local, state, and national governments, and as we heard this evening, even to the Lubavitcher Rebbe, or at least those associated with him. Mr. Waxman devotes hundreds of hours each year to pro bono clients in cases involving religious liberty, discrimination, habeas corpus, individual rights, and criminal justice. He has long been involved in Jewish organizations. He is a past recipient of the Learned Hand Award from the American Jewish Committee, the ADL Benjamin J. Cardozo Certificate of Merit, and the Pursuit of Justice Award from the International Association of Jewish Lawyers and Jurists. And as a particular point of pride to us here at JTS, Mr. Waxman is a product of the conservative movement in Judaism. He grew up in the Emmanuel Synagogue in West Hartford, Connecticut, met his wife, who is with us here today, Debbie Goldberg, through United Synagogue Youth, and has been a member of Adas Israel Synagogue in Washington, D.C. for the past 34 years, and I should add, synagogue which my wife, Michelle, and I were members, and we got to know Seth and Debbie during those wonderful years that we were together. Our program tonight will proceed in the following way. We'll first hear from Mr. Waxman, then Rabbi Danny Nevins, the Dean of JTS's Division of Religious Leadership, and the Pearl Resnick Dean of the Rabbinical School, and a member of the Conservative Movement's Committee on Jewish Law and Standards, will moderate the Q&A portion of our program. Rabbi Nevins will pose a question or two to Mr. Waxman, and then we will invite questions from the audience. It is now my great privilege to call to the podium Seth Waxman to deliver tonight's address.
Thank you very much for the generous introduction and for the generosity of inviting me to come here. I would have found it impossible to say no to the Jewish Theological Seminary, which, as Mark indicated, has trained almost every rabbi I've had in my 320 years of life on this earth. It was a special pleasure when Mark said, now, you know, this is an endowed lecture in memory of Bernie Segal, who I am old enough and steeped enough in the legal profession to have known and admired during his lifetime. So I'm delighted to be here. The seminary said, you know, you can come, this is for lawyers or judges, you can come talk about, you know, some interesting Supreme Court case or, you know, anything, you know, you think would be interesting to the seminary community and the general community. You know, some Supreme Court case you just argued in the issues. And I'm like, I am not coming all the way to my religious seminary, the seminary that trained my rabbis, just to talk to give the same kind of talk that I give in universities around the world. I'm going to do something really crazy, which is come to the Jewish Theological Seminary and talk about my lay understanding of Jewish law. You'll have to be the judges of whether this is really crazy or, something that I probably should not have done. But I thought that it was a challenge, and I thought that by giving the talk that I'm going to give tonight, I could replicate for a broader audience the kind of thinking that I've done throughout my legal career. And I started preparing for this lecture by returning to a question that was posed to me when I first embarked in the private practice of law in 1977. I joined a small law firm, and the managing partner of the law firm, a man named John Joseph Cassidy, a cheerful and very engaged Roman Catholic, sat me down to lunch pretty early on in my career and said, "Why do you think that Jews and Jesuits are so drawn to the law?" And at the time, I didn't think I knew any Jesuits. And he said that he was convinced that Jews and Jesuits excelled at the law because they both come from religious traditions steeped in wrestling with the meaning and application of God's law. A muscular, intellectual engagement with religious texts. And it is true that over the course of my career, it's actually impossible to count the number of times that the terms Talmudic or Jesuitical have been used to characterize particularly detailed discussions about how a specific legal principle should be interpreted or applied. And while it's certainly fair to say that the meetings of the American Law Institute may not quite resemble the Talmudical academies of the Babylonian exile, I think that the great rabbis of that era and those that have followed would actually feel quite at home if transplanted into those meetings today. At least that's how I've thought about Judaism and Jewish thought and the practice of law over the arc of my legal career. And it has led me over and over again through the years to ponder how consequential legal issues and constitutional issues that I've wrestled with would be viewed in the great body of Jewish text and commentary. Not just how they would be resolved, but equally important, or maybe more important, how they would be addressed. And that's what I'm going to set out to explore this evening. I'm going to take three very important cases that are currently pending in the United States Supreme Court, and the Supreme Court has really indulged me by not having decided any of the cases, even though I said I was going to talk about these cases, I believe, in November. I'm going to briefly explain what the relevant facts of the case are and what the constitutional issues are, and then explore with you some of the things that, and this is the chutzpah part of the talk, some of the things that Jewish law and learning would bring to bear if the question and issue were placed before the great Sanhedrin or a more modest, more modern Beit Din. So I'm going to start first with a case called Masterpiece Cake Shop versus the Colorado Civil Rights Commission, which was argued, I think, back in November or December, and surely is going to be decided quite soon. So in 2012, David Mullins and Charlie Craig decided to get married. They visited the Masterpiece Cake Shop in Denver, Colorado, to discuss a cake for their wedding reception. But when they explained what they were looking for, the bakery's owner, Jack Phillips, demurred. They could buy baked goods for other occasions, he said, but they could not buy a wedding cake. The next morning, Charlie's mother called to ask Phillips why he had refused to sell her son a cake. He explained that he was a devout religious Christian and because of his beliefs, his bakery had a policy of refusing to provide baked goods for weddings of same-sex couples. Charlie and David filed a complaint with the Colorado Civil Rights Division, the state agency that enforces a Colorado law that prohibits businesses from denying goods and services based on race or religion or sexual orientation and certain other specified characteristics. Phillips responded to the complaint that he had not turned down the couple because of their sexual orientation, but because he, quote, could not in good conscience create a wedding cake that celebrates their marriage. He also noted that he refuses to design and sell other cakes that conflict with his religious beliefs. For example, he won't sell cakes that have Halloween themes or that celebrate a divorce. He asserted that the First Amendment, the concept of a divorce cake was new to me too, but I learned a lot in preparing this lecture. Phillips asserted that the First Amendment to the Constitution, which forbids states from prohibiting the free exercise of religion or abridging freedom of speech, protected him from being compelled to provide wedding cakes to same-sex couples. The commission disagreed, and it ordered the bakery either to sell wedding cakes to anyone or to no one. Now, when the Supreme Court recognized the right of same-sex couples to marry in 2015, it foresaw that its decision would create tensions with the rights of religious organizations and people opposed to same-sex marriage. And this case presents the court with the first opportunity to resolve those tensions. It asks the court to weigh the values of anti-discrimination laws and principles of personal dignity and liberty upon which the court's 2015 decision rested against the expressive and religious rights of those who object to same-sex marriage. To what extent may the state enforce general anti-discrimination values when doing so may compel a person to provide services or have some connection with an activity in which they themselves would not participate on religious principle? So, the First Amendment protects expression, and Phillips argued that protected expression includes his wedding cakes because he says his wedding cakes convey messages about marriage and the couple being married. And he says the state can't compel him to deliver a message with which he disagrees, that same-sex marriage is a cause for celebration. Phillips also argues that Colorado's actions interfere with the free exercise of his religion because when he designs a cake for a wedding, he considers himself to be an active participant in a sacred event. And Colorado's law would compel Phillips to make art for, and in his view, thereby participate in events that he considers to be religiously objectionable. Now, on the other side, the state argues that its law is not regulating the creative or expressive aspects of Phillips' business. It only prohibits his discriminatory policy of refusing to sell a wedding cake to any gay couple. A state surely can't be able to require a baker to design a cake that says, "I support same-sex marriage." But if a baker will sell a cake of a particular design to some customers, it must sell that cake, the state says, to any customer, simply because the bake shop is in the business of selling an artistic product doesn't mean it gets to discriminate about whom it will sell it to. Now, Jewish groups have weighed in on both sides of the case. Jews for Religious Liberty and several other Orthodox groups have sided with Masterpiece Cake Shop. The Central Conference of American Rabbis, the Reconstructionist Rabbinical Association, and the Union for Reform Judaism joined non-Jewish groups in a brief supporting the commission. Conservative groups, shall we say, have kept their own counsel. Now, Jewish law has a lot to say about selling goods that are going to be used for something that a Jew might not do. Deuteronomy says, quote, "You shall not eat anything that has died a natural death. Give it to the stranger in your community to eat, or you may sell it to a foreigner." As Jews, we don't expect others to observe the same practices that we do, and we don't think they necessarily should, as the Torah acknowledges that it is perfectly acceptable for Jews to aid non-Jews in doing those things. For example, by offering them the non-kosher meat that we can't eat. I mean, it was only, 2 weeks ago that we all sold our chametz to non-Jews because there's no prohibition against a non-Jew owning or eating bread during Pesach. The texts, at least to my mind, become much more complicated, though, when it comes to the question of whether a Jew can help a non-Jew violate one of the so-called Noahide laws. Basic prohibitions such as not to worship idols, commit murder, or steal, that Jewish tradition says even non-Jews should abide by. In the Talmud, Masechet Avodah Zarah, the sages ask, how do we know, quote, that a person may not extend a limb severed from a living animal to a Gentile because eating such a limb is prohibited even for non-Jews? And the Talmud answers with a passage from Leviticus that says, you shall not put a stumbling block before the blind. That verse is construed broadly to put upon Jews the responsibility to refrain from doing anything that might lead another astray, physically or spiritually. And this includes refraining from enticing someone else to do an act that is, for him, prohibited. We aren't called upon to impose our beliefs on others, but rather to show compassion. We may not take advantage of another's spiritual or metaphorical blindness to hurt him. Avodah Zarah further considers whether a Jew may sell items used for idol worship. It is forbidden to sell items that are specifically used for idol worship. But a Jew may sell an item that is not specifically used for idol worship unless the purchaser says he intends to use it for idol worship. So if a non-Jew had come into the Jewish baker's shop and said, I'd like a cake to offer to my idol, the Jew should not sell him the cake. Rabbi Moshe Isserles, the 16th century commentary on the Shulchan Aruch, adds an important gloss. The prohibition of selling items that can be used for idol worship, he says, applies only if there are no other merchants who would sell the item. So if the non-Jew could buy the item elsewhere, it is, Rabbi Isserles says, it is permitted to sell. So from the apparently strict view of the Mishnah, the rabbis created an opening. A Jew may sell an item that will be used for a prohibited purpose if the buyer could simply buy the item elsewhere. So the Jewish baker can sell the cake to a non-Jew who wants to offer the cake to his idol, provided the non-Jew could have gotten the cake someplace else. But that doesn't answer the question whether the Jewish baker has to sell the cake to the idol worshiper. Because in certain circumstances, Jewish law has left the discretion to be lenient. It's important to think about Jewish principles that might encourage us to support the Civil Rights Commission to require the merchant to supply goods, even if the merchant knows they would be used for something that he considers to be a sin, and a sin for that person, the purchaser, to do. So there are two concepts I want to talk about. One is the concept of dina di malchuta dina. The law of the land is the law. We are instructed as Jews to obey the laws of the country that we live in unless they directly conflict with Jewish law. So where the law prohibits a merchant from refusing to sell his goods because of a customer's religion or sexual orientation, that law may not conflict with Jewish law if there are other merchants selling the same goods. In that case, Rabbi Isserly's caveat permits the Jewish merchant to sell the goods. And so a Jew is bound to follow the anti-discrimination law. The second relevant principle is mipnei darchei shalom, on account of the ways of peace. Maimonides explains mipnei darchei shalom with reference to two verses. Psalms 145, which says, "The Lord is good to all, and his mercies extend upon all his works." And Proverbs 3, which admonishes that the Torah's ways are ways of pleasantness, and her paths are paths of peace. Now, these verses are not explicit commandments, but they underscore the obligation to extend compassion to all people in order to create peace. In Tractate Gittin, the Talmud discusses a number of rulings the rabbis made mipnei darchei shalom. In some cases, this involved closing a loophole. For example, even though a lost item that is found by a minor is not technically acquired by the minor because the minor lacks legal competence, taking such an object from the minor is considered robbery mipnei darchei shalom. And likewise, early rabbinic rulings made exceptions to strict Jewish divorce law, mipnei darchei shalom, in order to permit women to obtain a get from unreasonable estranged husbands. Now, mipnei darchei shalom, in the sense that I'm talking about it here, isn't only about closing loopholes. Importantly, it is sometimes invoked to better relations among neighbors. For example, another passage in Gittin says, quote, "We sustain the non-Jewish poor with the Jewish poor, visit the non-Jewish sick with the Jewish sick, and bury the non-Jewish dead with the Jewish dead. All of this is done," the Talmud says, "mipnei darchei shalom," to foster peaceful relations between Jews and Gentiles. So, what if a non-Jew comes into a Jewish bakery, says he wants to buy a unique, beautiful, custom-designed cake to offer to his idols? If the cake can be obtained elsewhere, then Jewish law doesn't necessarily prohibit the sale, and the baker probably should sell the cake, both mipnei darchei shalom and because the civil laws prohibit him from refusing. But suppose every cake this baker designs is a product of his individual creativity. In fact, the reason the non-Jew has come to the bakery is precisely because he wants a spectacular, original cake for his idol. In that case, perhaps the baker is selling something that cannot be found elsewhere, in which case Jewish law would prohibit the Jewish baker from selling the cake, despite the command of the civil law. And this view jives remarkably with Masterpiece Cake Shop's argument in the Supreme Court. Phillips is arguing that his custom cakes are the product of unique artistic expression, and he believes that by selling these cakes for a same-sex wedding, he is contributing something that the couple may not be able to find elsewhere, his own personal expression of celebration. So, in short, maybe not so short, I think it's fair to say that Jewish values can be deployed to support either side in this case, which may suggest the reticent wisdom of the conservative movement in this secular legal debate. But I do think that I hope you'll see that this is an illustration that by engaging with the texts, we can really obtain a better perspective on the arguments on both sides. So the second case I'm going to address is Trump versus Hawaii, which involves what is popularly known as the Muslim ban. And so shortly, or maybe immediately following his inauguration, President Trump issued an executive order directing federal agencies to review what information is necessary to confirm that individuals who wish to enter our country do not threaten public safety. The Department of Homeland Security was then to recommend countries to be included in a presidential proclamation prohibiting the entry of nationals from those countries that don't provide sufficient information. And in the meantime, the president suspended entry of non-US citizens from 7 Muslim majority countries. The order produced massive confusion and massive protests, and courts quickly blocked its enforcement. The administration then issued a second executive order, which made some modest changes, and the Supreme Court then agreed to review the president's authority to issue that order. But then after the Supreme Court said it was going to review the order, the president superseded the second order with a proclamation, which now frames the issues before the Supreme Court in Trump versus Hawaii. So the proclamation says that it is the result of a worldwide review that developed a, quote, baseline for the kinds of information that foreign governments need to provide, and that applying this baseline, Homeland Security identified nearly 50 countries that were either inadequate or at risk of becoming inadequate. Diplomatic efforts, where the government has told the Supreme Court, yielded significant improvements from many countries, but not all. And the proclamation announced that 7 countries remained inadequate: Syria, Iran, Libya, Yemen, Chad, North Korea, and Venezuela, curiously. The proclamation exempted lawful permanent residents of the United States and dual citizens. It included provisions for case-by-case waivers, and it clarified that it would not cancel previously issued visas. For the 5 Muslim majority countries and North Korea, but not Venezuela, the proclamation restricts the entry of all immigrants, that is, all people who are seeking to become permanent residents of the United States. And it also restricts to varying degrees non-immigrants. So Hawaii and the other challengers asserted that the proclamation was invalid, both because it exceeds the president's authority under the Immigration and Nationality Act, and also because it violates the First Amendment's Establishment Clause, the provision of the First Amendment that prevents government from establishing a religion or furthering the establishment of religion. The lower courts in California found that the proclamation violated the Immigration and Nationality Act, and thus they never reached the question of whether the proclamation is in fact a Muslim ban in violation of the Establishment Clause. But a parallel case was brought in Maryland, and in that case, the United States Court of Appeals for the Fourth Circuit did hold that the proclamation violated the First Amendment, and the Supreme Court has agreed to review both the statutory and the constitutional issues. The case has now been almost fully briefed, and it's going to be argued at the end of this month. The challengers contend that I'm going to talk about the constitutional issues because they're most relevant for the principal issues I want to discuss, and also because we'll be here through breakfast if I explain what the provisions of the Immigration and Nationality Act are. So on the constitutional issues, the challengers are contending that the proclamation retains the same anti-Muslim animus that drove the earlier executive orders, and they say North Korea and Venezuela were added only to enhance the government's litigating position. The prior sanctions already restricted entry for North Korean nationals, and the proclamation's restrictions as to Venezuela are very, very limited. The government says, no, the multi-agency review and recommendation process and the country-by-country tailoring of the restrictions included in the proclamation provide a facially legitimate reason for excluding the covered foreign nationals. Several Jewish organizations and leaders have filed amicus briefs. The vast majority of them, from Reform, Reconstructionist, or unaffiliated but progressive groups, argue that the proclamation violates the First Amendment because it reflects government disfavor toward Muslims. And these briefs assert that increased anti-Muslim violence since the election is a direct result of that animus. And the briefs point to historical Jewish experience from biblical times through the incident with the St. Louis, as well as Jewish values, both welcoming the stranger and also treating others as we wish to be treated. The Zionist Organization of America has filed a brief in support of the administration, citing Jewish principles relating to defense and security. And the ZOA brief criticizes Jewish opponents of the administration for, quote, exploiting and making false analogies to the Holocaust and Jewish refugees. So, what to make of Jewish learning on this issue? Of course, there's no analog to the Establishment Clause in Jewish texts. The Jewish community is an establishment of religion. And nonetheless, there is extensive Jewish authority that bears on the propriety of the executive order. And as is so often the case, it points in different directions. Jewish texts, God, I hope that's not my phone. No, it's not my phone. Jewish texts repeatedly emphasize the importance of being welcoming and compassionate toward immigrants. Exodus commands us not to oppress or pressure the stranger as we ourselves were strangers in Egypt. We're told in Deuteronomy not to return a fleeing slave to his master, but instead, quote, let him dwell with you in your midst in the place he chooses, and not to oppress him. The sages of the Talmud pointed out that no fewer than 36 times the Torah declares that our experience as strangers in the land of Egypt obligates us to care for the most vulnerable among us, particularly the sojourners, migrants, and immigrants seeking refuge in our midst. That is a point that the Jewish Theological Seminary itself underscored in a public statement condemning the first executive order. And there's much more. Rav Kook, for example, wrote that having strangers among us is actually an essential element of a Jewish settlement. And citing those principles, over 900 Jewish clergy from around the world have signed onto a letter to Prime Minister Netanyahu urging the Israeli government to reverse its recent decision to deport Sudanese and Eritrean asylum seekers. But just as we are commanded to show compassion toward the stranger, so too we are taught the need to maintain the integrity of our borders and our population. Our commentary and history have recognized the practical need to impose some limits on immigration. First and foremost, Jewish law recognizes the importance of protecting the security of Jewish communities, including by protecting our borders. Deuteronomy prohibits any Ammonite or Moabite descendant from entering the Jewish community because when the Israelites left Egypt, rather than meeting the Israelites with food and water, those nations hired Balaam to curse them. And in Moses' blessing to the tribe of Asher before his death, he says that, quote, the bolts of their gates will be iron and brass. Commenting on that phrase, Rashi explained that, quote, the mighty men of Israel would dwell in the border towns and lock the frontier so no enemies could enter. It was as if they were closed with locks and bars of iron and brass. And in its amicus brief, ZOA also invokes the principle of pikuach nefesh, which emphasizes the importance of making every effort to save a life. ZOA argues that, quote, properly vetting persons wishing to enter the country and keeping out those who cannot be properly vetted comports with those values. Jewish law also makes room for economic protection. For example, in the Talmud, Tractate Baba Batra, Rav Huna says that a community can keep its economic markets closed to outsiders, although he notes that an exception should be made for those willing to join the economic community by paying taxes and participating in the economy. And finally, Jewish law has long recognized the need to protect the Jewish community from immigration that results in that risks assimilation. Deuteronomy commands Jews to cast out idol-worshiping nations, and expounding on this, the Mishnah Torah teaches that in the Jubilee year, Jews are forbidden to allow an idolater among them, even as a temporary resident or traveling merchant, unless the idolater adopts the Noahide commandments. If he does, he becomes what is known as a ger toshav, a resident alien. And to further these anti-assimilation goals, in the Middle Ages, Jewish communities instituted a regime of chezkat hayishuv, or a residence permit. And this was a form of self-protection for vulnerable Jewish communities in exile. So, where does this leave us with Hawaii versus Trump? Jewish law clearly recognizes that certain needs of the community, bona fide security needs, for example, can justify limiting immigration despite our fundamental precepts about welcoming the stranger. And certainly we all expect our government to take precautions that are truly necessary to protect our security, our economic prosperity, and perhaps even our so-called way of life, which is arguably the equivalent of Judaism's anti-assimilation concerns. On the other hand, as a global superpower, we bear little resemblance to the vulnerable Jewish communities of ancient Canaan, the Babylonian exile, or the Middle Ages. And really, the heart of the U.S. constitutional question is whether the proclamation really is a genuine exercise of the president's authority to take appropriate actions to protect national security, or is it really an act of anti-Muslim animus described as a security measure? It bears note, I think, that even Jewish principles permitting restriction on immigration have limits, including limits that allow people to prove themselves as individuals rather than to be judged categorically. I'm going to set aside the Ammonites and the Moabites and say that generally Jewish law provides that a non-Jew can become a Gesher Toshav by denouncing idolatry and accepting other Noahide laws. And strangers can join an economic market if they pay taxes. And even the laws surrounding the medieval Chezkat HaYishuv permitted temporary exceptions for refugees in exigent circumstances. At the end of the day, Jewish law and Jewish values expect us, where possible, to treat people as individuals rather than impose categorical bars in the name of security. A balancing exercise that is, with very limited exceptions, missing from the proclamation. So I have one final case to discuss. It is, in fact, the case that was the occasion of my 80th argument in the Supreme Court. It's called McCoy versus Louisiana. And McCoy versus Louisiana presents to the Supreme Court a question that at first blush would seem to answer itself. The Supreme Court granted review of a death row inmate's petition that asks, quote, whether it is unconstitutional for defense counsel to admit the accused's guilt to the jury over the accused's express objection. Most people are shocked at the prospect that if we were charged with a crime and we pleaded not guilty and we engaged an attorney to defend us, that attorney might lawfully be permitted to decide to confess our guilt to the jury. That was, as you could probably tell from my tone of voice, that was my reaction when I was asked to undertake Robert McCoy's case. This cannot be. So, in brief, here are the facts. McCoy was indicted for the murder of 3 members of his estranged wife's family. From the very outset, he maintained that he was innocent and that indeed he was not even in Louisiana on the day of the murders. But the state's evidence seemed overwhelming, and McCoy's lawyer, a man named Larry English, didn't believe that he could corroborate his client's professed alibi. He thought the only way to save McCoy from execution was to admit McCoy's guilt and plead for his life. And that strategy does sometimes succeed. But McCoy flatly rejected this plan, or indeed any approach short of putting the prosecution to its burden of proving each element of capital murder beyond a reasonable doubt. And the impasse between the lawyer's strategic decision and the client's insistence was presented to the trial judge. The trial judge ruled that the choice was the attorney's to make. And so English began both his opening statement and his closing argument by telling the jury that Robert McCoy, in fact, had murdered the 3 victims. He asked the jury to return a verdict of non-capital murder, or alternatively, to sentence him to life on the capital murder charge. The jury did neither. It sentenced McCoy to death. On appeal, the Louisiana Supreme Court rejected McCoy's argument, now presented by new counsel, that under the 6th Amendment to the Constitution, the decision whether to admit guilt or instead require the prosecution to prove guilt was his, the client's, to make. Now, 15 years ago, in a case called Nixon versus Florida, the Supreme Court addressed a case that was remarkably similar, but with a potentially significant difference. In Nixon, when the defense attorney told the client that he planned to admit guilt in an effort to avoid the death sentence, the client did not object. He also did not agree. He simply sat mute. And in a unanimous opinion written for the court by Justice Ruth Bader Ginsburg, the Supreme Court held that under those circumstances, the decision to admit guilt was indeed the attorney's to make, because the attorney had a strategy, he presented it to the client didn't oppose, in fact, did not engage. Now, our position in McCoy is that the client's objection makes all the difference. The choice whether or not to admit guilt or to pursue acquittal, we argue, is very much the client's to make. Where, as in Nixon, the client declines to choose, the attorney has to do what he or she thinks is best. But here, unlike Nixon, McCoy made the choice, and we argue that choice had to be honored. The 6th Amendment to the Constitution, after all, guarantees a criminal defendant the right to the, quote, assistance of counsel for his defense. And while the Supreme Court has held that the engagement of an attorney by a client authorizes the attorney to make all sorts of decisions about how to conduct the trial, what witnesses to call, what arguments to make, what objections to raise, the fundamental objective of the representation, whether to admit or deny guilt, is for the client whose defense the attorney is assisting in. So let's think about this under Jewish principles. As I did very hard back when I was writing my brief and preparing to argue, and confronted at the outset a formidable difficulty. Because in Jewish law, over the millennia, one accused of a crime had no lawyer. The defendant himself was responsible for presenting whatever defense he wanted to make. Still, I wanted some guidance on this, and I did find that there are Jewish principles that I thought speak to the relevant issue and is, I was going to say inevitably, but maybe so often the case, the principles point in different directions. Jewish law, for example, recognizes the relationship between a principal and an agent. And except in extraordinary circumstances, under Jewish law as under civil law, it is the principal, not the agent that the principal hires, who gets the final say over what the agent may or may not do in the name of the principal. As the Talmud, tractate Kedushin, explains, quote, "A man's agent is equivalent to him himself." And we learn from the Mishnah Torah, quote, "When an agent intentionally violates the instructions of his principal, his deeds are of no consequence, for the principal can claim, 'I sent you to improve my position, not to impair it.'" That would certainly seem to strongly favor Mr. McCoy's right to prevent his attorney from violating his express instruction. And yet, consider pikuach nefesh, the Jewish principle that preservation of human life overrides virtually all other considerations. Pikuach nefesh derives from the command in Leviticus, "Neither shall you stand by the blood of your neighbor." Under pikuach nefesh, one must do everything in one's power to save another's life. And that is what Mr. English thought he was doing. Now in McCoy, we argue that a third principle, personal autonomy and individual dignity, accords the decision definitively to the client. After all, it is his life and his liberty at stake, and it is his defense under the Sixth Amendment. In other contexts, the Supreme Court has recognized the, quote, "fundamental legal principle that a defendant must be allowed to make his own choices about the proper way to protect his liberty." Larry English saw his legal and ethical duty as saving his client's life. But Robert McCoy made the considered choice to accept a greatly increased risk of execution in exchange for the slim chance that he would in fact be found not guilty. And above all, he could not abide, even at the risk of his own life, having his own lawyer tell the jury that he had deliberately killed members of his own family. Now, is there an argument that Jewish principles similarly afford primacy to free will and personal autonomy? When I first began thinking about this, I assumed that the answer would be yes. I think in fairness, I assumed the answer would be a qualified yes, because asking almost any question like this about Jewish principles can at best only yield a qualified answer. And also, in the back of my mind, I guess, I should have known that although American Jews value individual freedom as much as other Americans, the fountainhead of those Western liberal values, our Bill of Rights, the philosophy of John Stuart Mill and John Locke, is not of Jewish pedigree. But I was quite surprised to discover that far from a qualified yes, the answer to the question of whether Jewish principles similarly afford primacy to personal autonomy is a pretty unqualified no. Pirkei Avot teaches that, quote, "the only free person is one who is concerned with Torah." The Jewish legal system I think, reflects the fundamental belief that we are all born avadim to Hashem, servants to the Almighty, and while we have free will, Judaism's central principle of mitzvah, which after all means commandment, reflects our obligation to live life in service to God according to a compendium of rules and practices. In fact, while the absence of defense counsel in rabbinic courts leaves a gap in Jewish legal thought on the authority of an attorney agent, there is extensive halakha around the very limited circumstance under which the death penalty is permitted, much of it focused on the primacy of pikuach nefesh. In fact, Jewish law, this is another revelation, prohibits the death penalty where there is a unanimous decision by the rabbinic jury, in part due to fear that this must mean that pikuach nefesh was not sufficiently considered. So while in our system, the death penalty requires a unanimous vote of guilt and execution by the jury, under Jewish law, that unanimous determination disqualifies the carrying out of the death sentence. Now, as I said, Larry English was very much focused on saving Robert McCoy's life. He believed the best way to do it was to admit McCoy's guilt. Is the pursuit of pikuach nefesh, which in Jewish law overrides virtually all other religious proscriptions, sufficient to overcome principal agent duties? It certainly does in other contexts. If a terminally ill patient asks her doctor to assist in ending her life, or even to withhold further treatment, in most instances, Jewish law prohibits the doctor agent from complying. Concerning the laws of Yom Kippur, Maimonides teaches that, quote, when a person who is dangerously ill says that it is unnecessary for him to eat, and a physician says that it is necessary, he should be fed. Perhaps the principle of pikuach nefesh overrides the principal-agent relationship because Jewish law refuses to honor a person's choice to die. The Shulchan Aruch says that, quote, if a captive has property but does not wish to ransom himself, the community takes his property and ransoms him against his will, because a captive's life is considered to be in danger. Pikuach nefesh overrides the captive's desire to preserve his property, perhaps for his descendants, even if it means dying. Our laws, and I mean our Jewish laws, provide particular and circumscribed exceptions. A woman standing under the chuppah, for example, may choose for any reason or no reason at all not to accept the ring on her finger. But beyond limited instances like this, personal autonomy is little valued in traditional Jewish law and rarely in Jewish thought and rarely protected in Jewish law. Quote, true autonomy, Rabbi Sherry Kohler-Fox has explained, quote, comes when people can live free of the limitations of human nature by attaching themselves to a higher authority. I must say that in the entire thought-provoking enterprise of preparing this lecture, that realization, far more than any other, set me back on my heels. And so I think it's safe to say that personal autonomy is no match for pikuach nefesh, as the Shulchan Aruch's directive to ransom a person against his will illustrates. And thus, in the case of Robert McCoy, Jewish law would very likely favor the trial court's ruling that the attorney could pursue the course he believed would most likely save McCoy's life against McCoy's own considered choice. That is not how I think, certainly not how I hope, the U.S. Supreme Court will rule. And it might not even be the way a Bet Din would rule if the prosecution had not sought the death penalty, because pikuach nefesh would not enter to trump general principles of agency. And that, too, reflects a difference with how I predict the Supreme Court will rule, because it is most unlikely that the court will hold that the nature of the penalty the prosecution seeks changes the constitutional calculus. But we shall see. I pray that I have not strained your patience in sharing what for me has been a totally delightful, engaging exercise in imagining how these three important cases with which our U.S. Supreme Court is now wrestling might, in fact or in fancy, play out in an imaginary Supreme Court of Judaism. Thank you sincerely for listening.
On behalf of all of us, I know that we're just so grateful for the wisdom that you came to us with and the incredible amount of Jewish learning that you exhibited. I know with 80 hopefully successful arguments in front of the U.S. Supreme Court, you may feel that you've established what you wanted to do in your career, but I want to tell you that if you decide after that you'd like to try a second career, I'd like to offer you admission to the rabbinical school here at JTS. I think that would be fitting his vote. That's wonderful. So
well, thank you. Debbie and my bride and I will take it under consideration.
So I have two questions, and then we'll open it up to the group. Starting with the last point, and you brought up the important principle of shlucho shel adam kamoto, that a person's agent is like the principal and can act on their behalf. There's an additional argument that zakin lo la'adam shelo b'fanav, we can also give benefit to a person without their knowledge and even without their consent, which could strengthen that. And against that, you held up pikuach nefesh, the need to save a life. And of course, the key thing is we don't know which strategy would have been better for Mr. McCoy's life to be saved. And then you raised this issue of ransoming a hostage against his will to spare his property. But I'm going to tell you about a 13th century case, a very famous case of Rabbi Meir of Rothenburg. Rabbi Meir of Rothenburg was one of the great rabbis of the Middle Ages, and he was taken hostage and for ransom, which was something that was done then as today, unfortunately. And the Jewish community created an international effort to ransom the rabbi. It was led by another great rabbi, the Rosh. And they raised, I think it was 24,000 pieces of silver to ransom the rabbi. And he refused to let them ransom him. He said, I want to die in jail. Don't you dare give them any money to save my life. Because if you do, then they're just going to start taking rabbis hostage left and right. And so the community actually accepted his agency there against their sense of his life. He did die in prison after 7 years of imprisonment. So if you were Rabbi Meir of Rothenburg's lawyer, I guess my question is, what would you advise the rabbi? Do you, or the Jewish community? Do we respect the rabbi's agency and his sense of what is the higher value in this situation, even if it means he will die? Like Mr. McCoy, maybe it was a higher value not to admit to murdering 3 members of his family, even if that meant that he himself would die. Or do you say, no, we got to get this rabbi out of prison, he's going to die, his life is of eternal value, and we need him out here in the community?
So one of the great things, to my mind, of being a lawyer is I get hired by one side or the other. So I guess I need to know before I respond, whose lawyer am I? Because I can, it's a very interesting idea, and certainly it poses a provocative counterpoint to the point that I was deriving from the Shulchan Aruch. On the other hand, you can say that the rabbi hostage, by convincing his supporters and followers not to ransom him, was in fact engaging in an act of pikuach nefesh on a grand scale. Because if in fact his prediction was right, that if this ransom were paid, many other Jewish scholars and sages would be captured upon threat of death in the absence of a payment of a ransom. You could say that he was pursuing, I'll see your pikuach nefesh and raise you, others. And, in fact, I think that if you think about the modern day policy, and certainly the policy that Israel almost inevitably adheres to, which is not to ransom even the most beloved, of its soldiers, because of this problem, I'm just guessing that one or two rabbis, grand or otherwise in Israel, have themselves blessed this refusal to ransom, and supposing that it is in fact on the terms of pikuach nefesh itself.
So you support the rabbi, Governor Mayor of Rothenburg, and even though his life is the one that's an immediate danger, the other one is a theoretical danger that it may happen, but maybe the community would be able to protect its rabbis, who knows?
Well, as his lawyer, that's the argument that I would make, because I would accede to my client's wishes,
Right.
not to himself, through his ransom, be the agent of the hastening of the deaths of other people.
Okay, thank you. And now let's go back to Masterpiece versus the Colorado Committee of Civil Rights Commission. It's true that JTS may not have made a statement on that case, but we did make a brief on the DOMA case and came out very strongly in favor of gay marriage and the rights for same-sex marriage. And in fact, I've been involved in that as the author of the 2006 paper in favor of gay rights, which led to gay ordination here, and the 2012 paper with two other rabbis of our same-sex marriage ceremonies, which I was able to give to President Obama before he endorsed same-sex marriage, and as part of our case that this is what was just. And yet, let's imagine that the Supreme Court does go against Masterpiece. My question for you on behalf of the religious community is, are we at risk now? Not only those who are evangelical laicos, but let's say a synagogue that says, no, we won't allow your wedding to be in our synagogue. It's an interfaith wedding, let's say, and our synagogue doesn't allow that. Or a rabbi who perhaps is an independent rabbi who does weddings and takes out ads in the paper that they're available for weddings, but I don't do some weddings and I do other weddings. Are we at risk? And should the Jewish community, I understand the Orthodox community felt that way, should we be taking that risk seriously?
So I think the answer is yes, and by saying that the conservative movement is apparently keeping its own counsel, I wasn't, God forbid, trying to cast aspersions on the wisdom of my movement on this issue. I do think that a ruling in favor of the commission could raise a host of other problematic cases and line drawing problems for religious institutions and faith and religious believers. And the fact that the issue is not really whether, as an organization, JTS, or as modern Americans, we endorse the right of two consenting adults of the same sex or different sexes to consecrate their relationship through, holy vows. The Supreme Court of the United States, really under the leadership of Justice Kennedy, whose jurisprudence in this whole area has been quite an evolution, decided that we're going to leave aside all the issues of the freedom of speech or free exercise of religion of other people, when we say that a state may not prohibit people of the same sex from marrying. And the court was quite clear, as I think I said in the lecture, that it recognized that these tensions would arise. Now, they're two quite different aspects of the First Amendment that are at play here. There's, I'm an artist, this is an artistic creation, and artistic creation, stained glass windows are protected by the First Amendment, subway scrawls are protected by the First Amendment, my cake creations are protected by the First Amendment, and and that right of expression can't be interfered with. I didn't deal with that so much in the lecture because, okay, so let's say he wasn't creating the masterpiece of all time cake to celebrate this gay marriage. Let's just say it was a cake that said, congratulations, mazel tov on your wedding. The one that's more interesting and I think poses much greater risks for Jewish congregations and Jewish institutions is the free exercise, the provision of the First Amendment that says that the government can't interfere with the free exercise of your religion. And this is what comes up in the cases that the courts are wrestling with, whether, if you have a Catholic hospital that receives federal funds, can it refuse to provide abortion services or contraception or things like that? There is a real tension, and there really are two very strong values. And, in this regard, to me, it seems a little strange. I mean, first of all, a cake that has no religious significance, it's not as if, he's providing the chalice wine or something like that, something that you actually do need at a wedding. And the notion that I take, at full faith, although I can't fully appreciate how selling a cake to people for their wedding reception makes him a part of a religious celebration that violates his beliefs. But as you say, you've decided that you're going to allow, you will conduct weddings, but you're not going to conduct weddings of X, Y, and Z. I think a way to put the First Amendment issues in the Masterpiece Cake Shop really in perspective is to imagine that he refused. Let's say he belonged to the high church of white supremacy, and he believed that blacks should be allowed to marry and should be able to consecrate their relationship. And this was a fundamental religious belief. So he's just not going to sell wedding cakes to black people. I mean, I don't think many people would have a hard time saying, no. You're either going to sell cakes to everybody or you're going to sell cakes to nobody, but you're not going to not sell cakes to black people. Now, part of that intuition is there can't actually be a real religion that doesn't think this, but the Free Exercise Clause prohibits government from making value judgments about whether something is or isn't a real religion. And so my guess is that the Supreme Court, I think that the Supreme Court is more likely than not to resolve this in favor of the cake shop, this Supreme Court. And I think it will be really interesting to see whether it does so on the basis of this isn't a cake, this is an artistic expression, or this is a cake, but it's a cake that's celebrating a religious ceremony that is anathema to the baker. If they do rule for the cake shop, I think the justices are all going to be exceptionally mindful of the slippery slope that could embroil other religious people, other faith-based organizations, and faith-centered people. So I think we probably will, let's say, we'll get an opinion that reflects some Jesuitical or Talmudic reason.
Thank you. Okay, we're going to open up to both the people who are physically present and also if we get any questions from the audience that's online. They should be sending in their messages and Rabbi Evelyn will bring them to my attention. So here in the front, we do some microphones. If you don't mind using this. Sir, in the front here.
Thank you for a fabulous lecture. I just wanted to ask you, in the viewpoint when Rabbi Moshe Salu was allowing the individual to provide something for the idol worshiping because they could get it somewhere else, was there a difference between providing wood that they would be using in the sacrifice and which they could get anywhere, or turning on the fire, or participating, or in some other way feeling like they are a part of that idol worship. And wouldn't that suggest then that the difference would be whether or not he's providing flour to the people who are going to be using it, or he's providing something where he is actually participating in it?
So that's a really great question, and I think, in fact, we actually do have a religious scholar here and some lawyer who's on a busman's holiday tonight, but the cases involving the selling of goods to an idolater, actually, the ones that I saw actually do involve selling wood, which of course could be used for, and the example is somebody comes in and says, you're Jewish, you sell wood, I want to buy wood, of course you could sell it. But if that person comes in and says, I want to buy wood because I'm going to use it to create an altar to my idol, you are prohibited from selling that, subject to Moshe Isserli's caveat, even though you're not going to do it, you're not going to participate in it, because you know that it is going to be used to violate one of the 7 Noahide commandments, which we believe apply to all human beings. In other words, you will be putting a stumbling block before this blind idolater. The example in which you're being hired to light the blessed fire, the paganistic idol-worshiping fire, involves a question of whether you yourself will engage in conduct that not only violates the Noahide commandments, but is proscribed to Jews, and therefore it would be a stronger case. And I cannot imagine any Supreme Court of the United States saying, not only do you have to sell the cake, but you have to come consecrate the wedding, because that would involve you, insinuate you in a very immediate way in a religious practice with which you disagree. I don't know if that's helpful, but it's the best I can do.
Not only because of the prohibition on you yourself in providing it, but also on the feeling that the permission to give the wood did not require you to do anything. The moment you were doing something else, you were helping this individual, from his point of view, to violate the Noahide laws. So it's not just that you're violating the requirements of the
Right.
but you're also prohibited from helping him to do the Noahide laws, but you're lighting the fire. So it's not. That's slightly different than what I think you were saying.
Well, what I'm saying, and just for the purpose for the remote audience, what I'm saying is that the Mishnah precludes the Jew from selling wood, simply selling a piece of lumber to an idolater who he knows is going to use it to create in idol worship. And it's not because there is something about the selling of the wood that that transgresses Jewish law for the seller. It's because following the commandment of not putting a stumbling block in front of the blind, you are not allowed to do something that would enable or entice a non-Jew from violating a universal proscription.
To make it just a little harder, there's a new book by a scholar named Mira Wasserman called Jews, Gentiles, and Other Animals. And it's really about the continuum of life, and she points out that tractate that it originally comes from, Avodah Zarah, does not speak about idolaters, Achim, but about non-Jews altogether, right? And in the manuscript of that tractate, which is here at JTS, it's before it was redacted. In the 16th century, a lot of our sacred texts were censored, and they were shifted from the more incendiary use of the word goyim, non-Jews, to idolaters, Achim. And what she points out is that they quickly shifted the world from Jews on one side and everybody else on the other, to Jews, Christians, and Muslims on one side, and idolaters of antiquity on the other side, which was a very convenient move for both the Christians and the Jews, actually, to reduce those tensions, but I digress.
It's midnight, Yarmulke Shalom.
It is indeed. Okay, we had any other questions? Please, if you can stand, if you can come to the microphone, great. Otherwise, I think you should because the people online won't hear you. You can also pass the microphone.
All right, so I have a two-part question. Number one is, why didn't English just move to get relieved based on irreconcilable conflict with his client? And secondly, was English court-assigned or was he retained? Because I can't imagine a retained attorney doing that on such a fundamental point. I could see an assigned counsel doing that, having done criminal law, who I wouldn't say routinely disregards the wishes of their client, but they decide, and they're much more reluctant or less willing to go along with what the client wants because they're not getting paid by the client, they're not retained. So I'm a little curious as to whether English was assigned or retained, and secondly, why he didn't just move to be relieved based on irreconcilable differences with the client.
So he was retained, not assigned, and he didn't actually himself volunteer to be removed, and it is a long, complicated story. As you might imagine, I've distilled down the essential principles, but when McCoy was first arrested, he's indigent, he was assigned a public defender. The public defender refused to do any investigation of his alibi defense, and indeed, when McCoy himself had subpoenas served out for witnesses who would support his defense, his public defender got up and argued against them in court. And so McCoy said that he was going to, his family, his parents were going to sell their car and hire a lawyer, but in the event that they didn't hire a lawyer, he would represent himself. And the judge conducted, a hearing and determined that he was in fact qualified to represent himself. English then came in, was paid, I think, $5,000. And when the dispute, boiled up and they went to the judge just before the trial, and the judge said, you're the lawyer. McCoy said, he's not my lawyer. I told him when he came to my, to death to my jail cell, I told him he was fired. My parents are going to find another lawyer, and in any event, I want to represent myself. And the judge said, it's too late. We're going to trial. You're not representing yourself, and you're not, and Mr. English is your lawyer. So he wasn't, he didn't exactly leap to volunteer to get out of it, but he was very willing to step aside if the court would allow McCoy to replace him.
Okay, yes, again, go to the microphone.
My question is on case number 1. I'm pretty disillusioned with God's rationale in this, that if you're going to lose this sale to some other non-Jew, go ahead, you can sell it to him. But if no one else, okay, now you're going to be moral and say, no, I'm not going to do it. I mean, it's pretty materialistic, insidious, etc. All kinds of negative adjectives come to mind.
This is a man in our religious tradition wrestling with God's word and God's law.
And a chemical engineer.
But I think to the extent that that's a question, I think it's more appropriately addressed to the Dean of Religious Studies, the constitutional lawyer.
Well, I did go back and look up that Siman, that's in the Shulchan Aruch, it's in Yoredea 151, where Rabbi Moshe Isserles says this. He presents it as an enormous leniency. Imagine that you live in a society, you're in a small town, you're in a very small Jewish community, and the majority of the people in the community are of a different religion. And imagine even that you are of the opinion that they are an idolatrous religion. And if you were to say that doing any business with them, selling them vegetables, doing any business with them could in fact support their idol worship, right? In essence, you would be removing yourself from the entire economy. And you can say, oh, is it convenient he's coming up with something so facile so that the Jews can make a buck? But it might be a survival matter as well in certain societies. So I think Rabbi Yisraelis was working in Krakow in the 16th century, where today, we follow the Meiri and say that Christians are not considered in the category of idolatry, but that wasn't necessarily the opinion of everyone. They saw Catholic churches with statues of Mary and Jesus, and they thought, and the Talmud says you're not allowed to do business 3 days before and 3 days after their holidays. The Roman Catholics have a lot of holidays, and so that would basically rule out pretty much every business day of the year. Now, we've got a lot of holidays too, but we don't do business. So, to say that you can't do any business with them, even if it's just selling wine, let's say, that some of them might consecrate, or it's selling grain, which they might turn into altar breads and wafers and things like that, I think would be an enormous hardship on the Jewish community. And it's possible that the Ramah, remember, who's working in a Christian context, whereas Rabbi Caro is working in a more Muslim context, when no one considered Muslims to be idolaters. It could be that Rabbi Caro was able to take a more stringent perspective because it wouldn't have as large of an impact on his Jewish community than what Rabbi Yisraelis did. So, rabbis don't work in isolation from their community and from the marketplace or the economic realities. And I wouldn't be too quick to dismiss the difficulty of the position he was in.
Maybe my problem is in generalizing it and embracing it furtherance of the theory that because you're not actually proscribed from doing it under the 16th century contextual interpretation, therefore, under the principle of Dina Malchuta Dina, you're required to do it.
Right. Yeah, that is interesting. I'm not sure, though. Dina de Malchuta Dina is this general principle that the economic rulings of the government, obtain. So I can't claim inheritance law. We're going to follow the Shulchan Aruch and not the state of New York or whatever. But I'm not sure that would require you then to sell to people. That in other words, it's going to determine property rights based on the government. The government has a right to seize property. Classic case is they're building a bridge and they seize all the trees from my woods, to build the bridge, instead of going to everybody else and being fair about it. Yes, they're allowed to do it. But I'm not sure we go that far to say that you're required to sell to everybody without any of your own religious qualms playing in.
So if that's the case, then certainly under Jewish law, the cake shop wins.
Yeah.
Because the principle of Darfei Mipnei Shalom at most gives you discretion to do something that might otherwise technically be proscribed, but for the purpose of establishing and generating peace, you will take advantage of a loophole. But it doesn't, the only authority I could find that would mandate somebody who believes that doing something violates his or her religious precepts is required to do it, is if in fact there is, the religion permits leniency and the civil law requires it. And that's, I think this discussion does point.
I'd have to look into that one.
Yeah. And, maybe that's why, although the court heard argument in this case in November, we're still waiting. They're still looking at, whether to follow, Rabbi Caro or Rabbi Yisraelis. What is the relevant context here?
That would be wonderful. All right,
Our time is up. I want to thank very much Seth Waxman Thank you all and have a good night. I hope to see you at another program here at JTS.